the law when they are in front of our state Supreme Court. These are principles that have motivated me throughout my legal career. I have been an attorney in private practice where I learned how to litigate cases. I was the law and policy director for Planned Parenthood of Wisconsin, where I worked to make sure that health care was accessible and affordable for people, and I worked to make sure that patients had the right to make their own personal private health care decisions. I then spent 9 years in the state legislature where I worked to expand access to affordable health care, to protect our environment, including our clean water, and I worked every day to try to ensure that working people of the state of Wisconsin who make the pie get a slice of the pie instead of the leftover crumbs. In 2020, I wanted to get back to the courtroom. I missed it greatly. Then I became a circuit court judge where I presided over thousands of cases, had dozens and dozens of very complicated jury trials. My goal every single day was to make sure I was protecting the constitutional rights of victims and of the accused. In 2023, I was elected by Wisconsinites from 24 counties to the Court of Appeals, where I work every day to solve complicated legal problems. I do every day what the state Supreme Court also does, but we have many, many more cases in the Court of Appeals. So these are the principles that really have guided my whole career, and I look very forward to earning your support in this very important race. We are again going to see the billionaires and the special interests try to buy a seat on our state Supreme Court, and just like we did last April, we must resist this effort to buy justice, and we must elect a justice who is going to stand up for the people of the state of Wisconsin, and I know I am that justice. So thank you so much.
Thank you. Now we are going to conduct this interview with a series of questions. And I want to say that the candidate gets to speak for up to 3 minutes for each question. And we do have a timer, so we aren't going to go over time. That way we'll be able to do more questions. At the end of these anticipated questions, we might be able to get some questions from the audience. That if you've got a card to fill out, be sure to give it to a person who will be collecting those cards, and those will be first to us. And I'm going to start with an opening question. And I think perhaps Chris has already answered this question. But why do you want to become a justice on the Wisconsin Supreme Court?
That is such an important question, and it really gets back to my love of people, my love of the Constitution, and my love of government actually representing people and people being at the center of their government. I did not come from a family of lawyers. Nobody was lawyers. My family didn't even like lawyers, I don't think. But I learned from a young age, and I had a passion from a young age in standing up against injustice. I learned from my grandma, who was a single mom to my mom, that laws that actually protect working people, that allow them to organize and have a voice in their employment and allow them to be fairly compensated, allow people not just to survive, but to thrive. And that's how my grandmother survived, by getting a union job when she was a single mom to support my mom. And my grandma was able, through that union job and earning a fair wage, to send my mother to college, and she became a public school teacher. So I learned early on how laws can lift people up and change people's lives, and I am so passionate about that. But we need now more than ever a strong state Supreme Court. Our rights are being eroded. Our right to walk down the street and not be subject to unreasonable intrusion. Our right to speech, our right to peacefully protest, Even our right to make our own personal private decisions about our bodies and our lives is under threat. We must have a strong state Supreme Court to protect our individual rights and liberties. We also must have a strong state Supreme Court that performs its very important constitutional function in being independent. Our state Supreme Court does not take directions from any other branch of government. In fact, the state Supreme Court holds the other branches of government accountable when they act unlawfully and unconstitutionally. For example, our state Supreme Court in 2023 struck down legislative maps that some called the most gerrymandered maps in the nation. That is an example of the power and the importance of the state Supreme Court in holding the other branches of government accountable. Finally, we must have a strong state Supreme Court that safeguards our democracy, that protects the integrity of our elections and our right to vote. Some of you may remember that individuals tried to overturn our 2020 election. Our state Supreme Court rejected that attempt, but only by one vote. We must have a strong court to stand up for the people of the state of Wisconsin.
Thank you. The next question will be offered by...
Yes. My mic wasn't working before. I'm curious, Judge Taylor, how would you describe your judicial philosophy and how would it also guide your decisions?
Well, my judicial philosophy is centered on making sure every Wisconsinite has equal access to justice under the law. What does that mean? That means that it should not matter your status, it should not matter how much money you have. You are entitled to be treated fairly and impartially by courts. You're also entitled to be treated similarly to other people who are situated like you. And that's called equal protection, that people who are similarly situated are entitled to be treated with impartiality and in the same way. That is the whole concept of equal access to justice under the law. I am passionate about prioritizing the rights and freedoms of actual people rather than prioritizing the big money special interests that so often are trying to buy elections, and as we saw last April, buy a seat on our state Supreme Court. I am about people. That is what our democracy is about, and those are all my values that I bring to the bench right now, every single day as a judge, but this is what I will promise and bring to the bench as your state Supreme Court justice.
Thank you, Judge Taylor. Wisconsin Supreme Court races have seen record spending from outside groups. Do you support requiring a justice or judge to recuse him or herself from cases involving donors and indirect supporters who contribute money or other resources to the judge's election? If not, why not? If so, why, and what contribution limits would you set?
Well, this is a question that I'm asked a lot about. Back in 2010, our state Supreme Court adopted a recusal rule, a Supreme Court rule, that was proposed by some powerful special interests that were very involved in elections. It actually said justices do not have to recuse themselves based solely on the contributions they received into their campaign committees, or based solely on these issue advocacy groups that spent money in their elections. I oppose that rule. I think the rule needs to be re-looked at. That rule, again, was drafted by two very powerful special interest groups who are probably going to be spending money in this election against me, because they know I stand up for people And I'm very opposed to the process by which that happened. The people of the state seemingly were ignored. So what I would like to see happen is what Justice Karofsky, Chief Justice Karofsky, has alluded to. I would like to have a hearing on this issue and hear from the people of the state of Wisconsin. Now, my opponent does not support that, but I do. I think it is very important to hear from the people. What do they want to see in a recusal rule? What causes them not to have faith in the judiciary? There is nothing more important to me than the community in this state and the people of this state having faith in the Wisconsin Supreme Court and knowing when they go before that court they're going to get a fair shake. So I really would like to see that rule revisited. I don't know exactly what it should say. I want to hear from the people of the state of Wisconsin about what their thoughts are.
The court has faced a number of ideologically charged cases recently. How would you approach cases where public opinion might conflict with your interpretation of the law?
So I would approach a case like that how I approach every case. And I approach every case looking at what are the issues presented by the parties, what are the facts, what is the law, and what is the fairest, most impartial decision that I can make to resolve the legal dispute before me with always an eye towards justice. We take an oath to do justice. And that is always what we have to look at. So it doesn't matter to me what the case is in front of me. I take a reasoned approach in looking at what does the law say, what are the facts, and how should the law be applied in a way that is fair, impartial, and achieves justice for the parties. I will say this, I think it's so important. It's really imperative that our Supreme Court be independent. As I said, we are not a rubber stamp, and we never should be for any branch of government. In fact, we're supposed to be the check on making sure other branches of government are acting constitutionally and lawfully, a role that our U.S. Supreme Court seems to have abandoned. So we must have a strong state Supreme Court to do this. But I am so interested and have tried to practice in my own judicial career going out to be part of the community. We have to be independent. We can never be isolated from the people. I have spent a lot of time on the Court of Appeals going out to the counties that elected me, 24 counties, because they need to see me, what I do, what we do on the Court of Appeals, how we administer justice. So what I hope to do on the on the state Supreme Court is to continue that, is to go out and be part of the community, not be isolated. We must be independent. We should not be isolated from the people.
How do you handle legal viewpoints that are significantly different from your own in a collegial setting?
We need that more than ever, you all. I get to do that every single day on the Court of Appeals. I write my decisions, most of my decisions, some of my decisions I write as a one judge, so I'm the only judge on the decision, but most of my decisions I write with two other judges. So one judge is assigned to write the decision, and the two other judges give feedback. And we spend a lot of time talking about our decisions. We have an incredible group of 5 judges who I work with in District 4 on the Court of Appeals. We talk, we discuss, we argue, we don't always agree, but we are collegial and respectful, and I love that process. I love it because I hear opinions I may not have thought of. It makes my decisions better. My colleagues hear opinions from me that I think have made their decisions better. As I said, we don't always agree, but we respect each other, we listen to each other, we learn from each other. I am a collaborative person by nature. I love working with people. I love the challenge. And I love listening to people because that's how I learn. I learn from my colleagues. And that is the kind of collaborative spirit that I will bring to the state Supreme Court.
Judge Taylor, I'm wondering what advice you would give to undergraduate students like myself who are interested in legal or political careers.
Go for it. I love it. I'm so excited by the young people who I encounter. And I just absolutely love being on a college campus because this is our future, you all. This is why we do the work we do for our children and for their children. So my advice would be to really figure out what is your passion in life. My passion was people's rights. My passion was justice. And that's what drove me to law school. I would encourage people, young people, to really think about what is their passion in life. And if it's the law, if it's practicing law, if it's studying the law, absolutely, go to law school. Get some skills when you graduate. I was in private practice for a number of years before I got the job as the law and policy director for Planned Parenthood, which was a job I dreamt about in law school to be able to work on issues that I felt so strongly about. So I would encourage students to really think about what is their life's purpose and to pursue their dreams with an eye towards maybe not getting the ideal job right out of college or right out of law school, but building the skills so when that job comes open that you've always dreamed of, you're the one that that group wants.
What do you consider to be the most important qualification for a Supreme Court justice beyond the basic legal requirements?
That is such a good question. Well, I think a judge that has a diverse background, that brings something that might not be on the court, is very important. I have a very diverse legal career that I think makes me uniquely qualified for the state Supreme Court in that I've been in private practice, I've been in nonprofit law, I've been in the legislature, on the circuit court, and on the Court of Appeals. I have thought about the law, I have dreamt about the law from so many different angles that I think I have a great, robust, broad perspective that I bring. That is not there right now. My background is totally different. But beyond that, I think there has to be a really strong justice, you have to have great compassion for people. You have to have a great commitment to want to do justice for the people of this state. So I think we're having that commitment to constitutional rights, to people's ability to access justice, which can be very hard, and we need to work to eliminate barriers to accessing our courts. But then I think we really need justices that are going to have a spine of steel in defending our democracy, in defending the independence of the judiciary. The judiciary is under attack. Judges are under attack for just doing their job. We need to stand up strong because without an independent judiciary, our democracy is in jeopardy. And I understand that very clearly. I also feel like we need a justice who is going to protect our elections, the right of the people to elect their representatives. George Washington talked about the right of the people to elect their representatives, not the other way around. And that is a very important concept. And then finally, I will say in this moment, we need a strong Supreme Court to stand up for the independence of the state of Wisconsin and against the federal government's overreach. We are in charge of our elections here in the state of Wisconsin. We have a local control of our elections, and we need to make sure that our state independence is not being infringed upon by the actions of the federal government.
How do you view the court's role in cases related to election administration and voting rights? So for example, absentee ballots, voter ID laws, and then also the role of Wisconsin elections.
I alluded to this in my last answer, how important I think the state Supreme Court is in protecting the integrity of our elections, in protecting people's rights to vote. Fundamental to our democracy, we need a state Supreme Court who's going to be very, very strong. I have had election cases. We're actually seeing, I would say, more challenges to the ability of people to vote, more challenges to different processes that are administered during our elections. The court has a very, very important role in making sure, again, that people can vote, that there's fairness, and that when we have elections, that there is certainly no evidence of any fraud, no evidence that an election has been conducted unfairly. That election has to be upheld. The people's choice, the people's vote has to be defended by our courts.
Gerrymandering. Gerrymandering of state and federal legislative maps has been a significant issue in Wisconsin. What is your standard for evaluating the constitutionality of redistricting plans? And when should the court intervene in the map drawing process?
You all probably remember I think it was 2023, I alluded to this, our state Supreme Court struck down the legislative maps, finding them unconstitutional, because in our Constitution, in two separate places, is a requirement that the areas within a district be contiguous. So what that means is you can't have little blobs of the district that isn't connected to other pieces of the district. And our state Supreme Court said these legislative maps that were passed in 2020, that were really a continuation of the maps that were passed in 2011, violated our state constitution. I agree with that decision. Our state constitution does not allow non-contiguous areas in a district. So I think that was the right decision. In fact, I just read it again. It's a really great decision, you all. You should go look at it. Clerk, it's a clerk decision versus the Wisconsin Election Commission. And what I love so much about the decision, it looks at our state Supreme Court. And we cannot forget that our state Supreme Court affords us constitutional rights that we interpret here in the state, not the U.S. Supreme Court. We interpret those rights. So it's a really good decision in demonstrating how our state constitution protects fair, or at least districts that don't have little blobs of wards in them that are not connected together. I'm hesitant to comment further because there's a pending case on the congressional redistricting. What standard is applied in that case, I'm going to be really interested to see, because it's not clear. There hasn't really been. In fact, you all saw the U.S. Supreme Court did overturn the lower federal courts in saying these recent Texas maps could go forward, even though there was an acknowledgement they weren't constitutional. So that's a little confusing. That maps are not constitutional, but they still can be in existence. But I don't want to comment too much on what the various different proposals that have been made in the congressional context, because that is a pending case. But there has not been a specific standard adopted. There's been various different theories about how you could do fair maps so that people in the same community weren't being separated from one another. But I think that we'll see how the state Supreme Court and the panel that was appointed to look at those two cases come down on that.
So I know you kind of spoke about this earlier on, but describe which U.S. Supreme Court or Wisconsin Supreme Court opinion in the past 25 years that you believe has had a significant positive or negative impact on the people of Wisconsin. Explain why.
Sure. I think one of the worst cases, and I don't want to be a downer here and talk about all the bad things, but I think the Citizen United versus the Federal Election Commission case, this is a 2010 case, really unfortunately altered the election landscape by allowing corporations to make unlimited spending decisions in races. There were some limits imposed before Citizens United. It kind of opened the floodgate to corporate spending in elections. There was also cases that followed Citizens United that were really eroded campaign finance protections to make sure that the people's voice wasn't drowned out by this onslaught of money that corporations dumped. And a lot of the money, unfortunately, is secret. You don't even know where it's coming from because of lack of disclosure laws. That decision continues to reverberate throughout the nation and throughout our state. I think it was incredibly harmful for democracy.
Can you describe an instance when you were challenged and had to exhibit courage or impartiality in the face of adversity or opposition, and how you handled that situation?
So I would say when I was first elected to the legislature, it was in 2011, it was a very hard environment. It was a very politicized, a very partisan environment. But I really, as a representative, as someone who went there to get things done for my constituents, wanted to find a way to work across the aisle. And it was hard because there had been a lot of hurt feelings. There were a lot of things that had gone down before I got to the legislature that created a lot of animosity and I think really elevated the partisanship. But I made efforts to reach across the aisle to meet with people who maybe didn't share many beliefs that I had or many values that my community had who elected me. And I found people across the aisle to work on bipartisan pieces of legislation. It was a very hard environment to get through, but we did. We did it. We worked on things that continue to have, I think, a really important place in people's lives. For instance, working with another Democrat and two other Republicans, I was an elected Democrat to the legislature. This is a nonpartisan race, however, and I don't run as any party as a judge. But when I was in the legislature, we got a group of people together and we worked to pass the Safe at Home Act. This was a very important bipartisan law that allowed victims of sexual assault and domestic violence to get a state-sponsored P.O. box so they did not have to disclose their residential addresses, so they could keep their addresses hidden from the person if they were in the community who had abused them. And I just ran into a colleague of mine. I was in Milwaukee a couple nights ago, and he was circulating his nomination papers. We're all circulating our nomination papers because I'm on the ballot in April, it's coming up. And he said that one of the people who signed his nomination papers didn't disclose her address. She wrote Safe at Home. And that was the bill that I had helped get passed. And I was so happy that people are using that law to protect themselves, and yet they're still able to participate in our democracy, and they're still able to vote and sign, nomination papers because they don't have to disclose their residential address. So I was really touched that that law is still, I think, having a really big effect. But it was a challenge to come up with areas that we could get consensus around, and we faced a lot of roadblocks, but we did it.
Thank you, Judge Taylor. Now is the time for anyone who has written questions on the card Now I know I need my glasses.
How would you approach vaccine regulations, specifically regarding children?
Well, I have not had that issue come up before me in a case. I don't make policy, so I cannot comment on any kind of policy that's being proposed right now. That's not my job as a judge. But what I would do is look at the law, look at how this regulation was passed, see if it comports. It depends on how it comes to me. Is it a regulation that was passed by the legislature, or is it a regulation that was passed through an administrative agency? If it's an administrative agency under the state, we have a different process. That's called the Chapter 227 process, and there's certain guidelines that we look at as to whether an agency had the authority to promulgate that particular regulation. If this is in regards to what we're hearing are going to be some new vaccine panels coming up, I imagine that that would probably go to a federal court, because it's probably going to have to do with perhaps a federal regulation. But what the court does is look to see was there authority to pass this regulation, and that's really the process the court uses. If it were a state regulation, there's a process in the statutes that we follow to see if there was the authority to pass the particular regulation at hand.
Okay, I have one card in my hand. That is all.
You all don't have any questions?
These are our
Oh, there are 2 questions on this page. How do you feel about precedents in law and judicial rulings?
Precedence is important. A lot of what we look at when we are looking at a case that we have in front of us with facts of the law is how have we dealt with it in the past. So precedence is extraordinarily important. Of course, there's precedence that a new group of judges can say is unconstitutional. And the court does have, the state Supreme Court has the power to overturn precedent. I don't have that power in the Court of Appeals. We can't overturn our own precedent. So I would say it's very, very important. But there are instances where precedent really incorporated an unlawful and unconstitutional principle. I mean, a great example of this is a lot of the cases that came up in the civil rights era, such as Plessy versus Ferguson, which was a doctrine of separate but equal, which we resoundingly rejected by 1954, the Brown versus Board of Education, recognizing how unconstitutional that was, how unfair that case was, and it was overturned. So there's really important cases that need to be overturned because they unconstitutionally discriminate or they're just flat out unconstitutional. But precedence is also very important, and I'll give you an example of a case where I thought there was no good reason. Sometimes there's really good reason to throw out a case, like Plessy versus Ferguson. That was one of the worst cases probably ever decided by the U.S. Supreme Court. So there was good reason to say that was wrong. I will give you another example. The Dobbs decision, which overturned Roe versus Wade, I think, was a very ill-advised and bad decision for a lot of reasons, but one reason is because it threw out almost 50 years of precedent, including Roe versus Wade being affirmed in 2016. Well, what had changed? What had changed? And so there was no good reason there, in my opinion. That Dobbs decision was a political decision, that's all it was, and it jeopardized the health and the lives of women throughout this country. So that's an example of precedent being disregarded for no good reason.
So, three questions coming. Yeah, I'll start with the first one here. How much power does the state Supreme Court have over redistricting, and do you agree with this structure?
The state Supreme Court has power over redistricting, for sure. We just, as I alluded to, they overturned the 2021 legislative maps, or maybe they were 2021 legislative maps that were overturned because they violated the state constitution. The state Supreme Court was doing exactly what it's supposed to do, making sure that the legislature did not act unconstitutionally. In that case, they found they had acted unconstitutionally. So state courts are very, very important in making sure that maps are constitutional and that people's right to pick their representatives rather than the other way around is being protected.
I think I need to rephrase this a little. What role can the Wisconsin Supreme Court take when raids are conducted in Wisconsin to take in undocumented immigrants and not very appropriately?
So there is a role for our courts, our Wisconsin Supreme Court, because we have our own state constitution. And individuals who are in our state have to abide by our state constitution. And if there's an allegation that our state constitution is being violated, regardless of who it is, regardless of the employment status of the person violating it, that can be litigated and that can be charged. Now, the state Supreme Court would not, I don't think, be able to interfere with a federal officer's job or employment of the job that they were doing. However, again, there's nothing that I know of that would prevent the state Supreme Court from interpreting our Constitution in a way, our Constitution applies to everybody who's in the state. So if there is a violation of our state Constitution, that is an issue for our courts.
Do you support the Final Five voting? Do you support the Final Five of voting?
Is that ranked choice voting?
That's ranked choice.
Yeah, ranked choice voting. So again, when I was the legislature, I worked a lot on looking at voting issues and their elections and things. I don't take policy positions now. I can't. I'm a judge on legislative things. I think it's a really interesting concept as my observation as someone who votes and is interested in voting, but I can't take policy positions on those kinds of things. Those are issues for the legislature.
One more. Do you believe in a living constitution for the United States? You know what that means?
I think so. I think does our Constitution and these incredible principles evolve over time? I think that's how I'll interpret that, and I think absolutely. I mean, it doesn't make sense to say we are frozen in time in 1789. I mean, women couldn't vote. People of color couldn't vote. We lived in a different community. We didn't have so many of the modern amenities that we have now. It's just a different, society. So to the extent that I think our founders wanted our Constitution to be able to last, and those important constitutional principles be able to survive into the future, I do think it is our constitutions are living documents. But the principles, I think, that are embedded are beautiful, important principles that can carry over throughout time. as long as the promises of our federal constitution and our state constitution are applied to people. And some people were still don't have, full justice under our Constitution. So when you read our federal Constitution, particularly the 14th Amendment, it's a beautiful amendment. It promises equal protection and due process under the law. We just have to make sure it's actualized for every single person.
This person says, how can the state manage environmental issues and concerns of the citizens? And then they use data centers as an issue statewide.
The data centers.
So how can the state manage environmental issues and concerns of the citizens?
I'm not going to talk about how the state does. I can talk to you about how I do it as a judge when I have an issue that's of an environmental concern. Often we are it's an administrative rule that we are reviewing. Now, I don't know how many of you know there was an opinion by the state Supreme Court that the legislature just couldn't sit on these emergency rules forever, that was not constitutional. Rules were going into legislative committees on things like the environment, how do we protect our environment, and never getting out. And so there was a recent case that said the rules, they can't just be killed by the legislative process. As a judge, so that was a recent opinion by our state Supreme Court. Again, I look at how was the rule promulgated, how was the statute 227 followed. I will say that there was just another I thought, really good decision on this issue of environmental protection and regulations that come out from an administrative agency in this case. The Court of Appeals, in fact, the individual who was my opponent in this race joined a decision saying that the state did not have power to regulate toxic chemicals called PFAS in people's water. I disagreed with that decision. I thought it was an incorrect application of the law. It went to the state Supreme Court and they overturned it. Because the state, they found it was actually should have been given effect. It should not have been struck down by the Court of Appeals. So it was a regulation to allow the state to make sure people's water wasn't filled with toxic chemicals and to hold polluters accountable. The Court of Appeals, the person I'm running against, said no, the state could not implement clean water protections. The state Supreme Court thankfully reversed that decision. And so the state does have authority to make sure that when there's PFAS, these are toxic chemicals that last for a long, long time in our water, they can be addressed by the state. There can be safety mechanisms to protect people's health.
Thank you, Judge Chris Taylor.
Thank you all.
We are approaching 2 o'clock. And that is the limit of the time we have for today's event. This has been very illuminating, and it has also been very courteous on the part of the audience, part of my partner up here, and part of our candidate here. I want to thank you all again for coming. I want to thank all of our partners from the NARS Center, Community Conversations, the League of Women Voters of St. Croix Valley. I want to thank our videographer, Steve Hansen, and I want to thank Afton Greco, who helped us coordinate all this. I'm sure I left someone out.
So, thank you, Ellen, for helping out with this. And thank you to everybody who came today, and especially the students. UW-Stout needs to do a better job of helping our students with politics and understanding that. Thank you to the students who did come today.
Thank you all very much. My closing remarks are that because we are a nonpartisan organization, we will be offering the same opportunity to Maria Lazar on February 4th. I wrote this down. 5 p.m.? Thank you. Thank you. My notes are in a shambles. So that will be in February. And at that time, we will rebroadcast this event so that voters who have only woken up to the idea that there is such an election can look at both candidates and compare. And I want to remind all of you too that we have something called Vote 411, which is a League of Women Voters effort to get candidates to put their own words in a place that you can go to, vote411.org, that you can go to find out what they say. We don't edit what they say, they put it up. And if they don't put it up, we contact them and tell them they should. Because that is something, a way that you can find out some information that is not just a TV advertisement. And we strongly recommend it. Thank you again, Judge Creed.
Thank you to everybody.